Hello and welcome to Upfront and Legal. On this edition, Mark Crone is joined by Gary Schuster in a discussion about estate planning. As these attorneys with Jacobowitz and Gubitz, Walden, Poughkeepsie, and Monticello point out, though most people don't think they're wealthy enough to have an estate, there are good reasons for everyone to consider the consequences of not planning ahead. To open the discussion, here's Mark Crone.
We were talking about today what it takes to settle an estate in New York. First of all, I think it would be helpful to understand what an estate is. Basically, someone's estate is defined by a person's will, if there is a will, and also how property is titled in the state of New York. For example, most insurance policies name a beneficiary, and therefore the insurance proceeds upon a death go automatically to a beneficiary outside of one's estate, so it's not includable in an estate. New York state law also defines what an estate is and also defines what exempt property is. Exempt property would include the family Bible, family pets, tools, that sort of thing. Now, once you define what an estate is, people have to know what to do as far as administrating the estate. So the first step usually is taking a look at the will, if there is a will. Usually a will will define who an executor is and whether a bond is required. If you need a bond, you go ahead and contact an insurance company and obtain one. Sometimes a court will require a bond if the will doesn't say anything about that.
What's a bond for?
A bond is to usually ensure that the fiduciary, an executor or an administrator, actually carries out his or her duties, so that if a mistake is made, the executor or administrator would be insured in order to make up any monetary loss as a result of a mistake.
So it's kind of an insurance policy for the executor?
Well, that's exactly what it is, Gary. Gary Schuster, my co-partner here, basically, you hit it right on the nail.
Let me ask you, when you said how property is titled, you're talking about the title to a house, the title to a car. Sometimes it's got one name on it, sometimes it has two names on it. So that makes a difference when we're trying to figure out what's in the estate.
Yeah, let's go back to how property is basically titled and talk about jointly held property. Jointly held property will not become part of one's estate because it automatically goes to the survivor. So if you were to hold property, your house, say, with your spouse, and then one of you dies, the survivor would get the house automatically, and it would not become part of the estate for purposes of probate or administration.
You could also do that with a bank account, right? With a checking account, a savings account.
Many times you see that. People will put a banking account or checking account of some type in joint names so that one or more people or two or more people can draw the funds out at any time. And that's something else that will pass automatically to the survivor without the need of having to probate that asset. So you see sometimes in a smaller estate proceeding, you don't see any assets whatsoever that you can really probate. So there's no need to go to court, no need to apply for a probate proceeding or an administration proceeding. An administration proceeding is a proceeding that takes place without a will. So if everything is held jointly, you really don't have the necessity of probating or administrating an estate, and you really end up having to do nothing. It just all happens automatically.
So if someone is interested in fast access to money, a jointly held bank account might be a good way for them to go.
Well, it might be. The other side of the story, and people argue that for tax purposes, that's not so good of a way to go, because what happens is owning property jointly will bunch up the property in the surviving party's estate so that when he or she dies, you have a lot more property now includable for tax purposes. You lose some tax benefits such as the unified credit, which is currently $2 million. You can give away $2 million, which is nice to know, without the necessity of paying any taxes on it. So if you hold everything in joint names, though, you may lose that benefit of utilizing the unified credit. It depends on who you give it to. If you hold it with your spouse, then the tax law says, for example, that the marital deduction, the unlimited marital deduction, which came into play back when President Reagan came to office, takes over, and again, you lose the benefit of the unified or applicable credit now. It used to be called the unified credit, but now it's called the applicable credit. So if you do have property, though, that eventually does need to be probated in court or through an administration proceeding, you'll have to have an attorney prepare a petition for either probate or administration, which has to be submitted to the surrogate's court in the area in which the decedent had resided. In this case, Orange County is where we all reside. So that petition is usually prepared by attorneys. It names the person usually appointed. It would be the person appointed in the will. An executor is usually appointed in a will, and that's usually the surviving spouse or a child or a family member of some type. And if there is no executor named in the will, or if there's simply no will, if it's an administration proceeding, for example, without a will, then anybody in the family can serve as an executor or administrator as well as a creditor. So that's one of the things that we look at as we're going through an estate, just to determine, first of all, who should be the petitioner in connection with a will, or, again, if there is no will.
Now, if there is no will and there are perhaps several children, might there be a fight among the children? Somebody wants to be the administrator?
Oh, yeah. It happens all the time. Children are concerned with taking over. There's a lot of emotions sometimes in connection with mom or dad's estate, and they want to make sure that what they know about mother or father is done the way mom and dad wanted them to do it. So sometimes you do get into these controversies where someone would rather, serve as an executor or an administrator versus someone else. And that does happen, and it's understandable. There's a lot of concern for the parents' estate at that point.
But a way to avoid that fight would be to write a will and to name an executor.
That's absolutely true. That's advisable. But even if that's the case, everybody, you've heard the phrase, everybody is due their day in court. So once the will is submitted to the court for review, all the interested parties, all the family members have an opportunity to contest a named executor, even though the decedent did name somebody in the will. Another family member could come and argue that he or she should not be the executor of the will because of some problem, and then the judge has to decide ultimately who's appointed. Now, in connection with the administration of the estate, you have to also be concerned with marshaling assets and understanding the extent of assets that exist. Again, we talked a few minutes ago about jointly held assets. We're not really concerned with jointly held assets in this particular discussion because those assets, once again, are going to pass outside the estate automatically to the survivor. The kinds of assets, though, I'm talking about, and the kind of assets that we should be concerned about when we're administrating an estate, that are held in the sole name, in the name of the decedent individually. That might be securities, for example, stocks and bonds, tools that are in excess of $1,000 in value, and other types of assets such as a secondary home, that kind of thing. So with regard to assets solely owned by the decedent, we want to take a look at those and try to get a value for those assets for both tax purposes as well as for probate purposes. Because if there's no will, as a matter of fact, the court will charge a fee up to a maximum of $1,000, basically, based upon the value of property. So one of the things that we ask our clients to do when we're talking to them about settling an estate is to go through the papers that they can find in the house and ascertain what assets exist. Then after we know what assets exist, we're very concerned about insurance. We want to make sure that the insurance policies are current on any asset that requires insurance, such as an automobile, a house, that sort of thing. And we don't want to see insurance lapse during the period of time in which we're administrating an estate.
Now, talking about the property that a person owns, I know it's important to determine the value of that property as of the date of death.
That's right. The law states for tax purposes, the decedent's property is valued on the day the decedent dies. And that value is usually established by appraisers who can come in and take comparables in connection with a home, piece of real estate, or if it's a car, that can usually be easily determined by looking up the NADA value, National Automobile Dealers Association value on the day of death for that particular automobile. If it's a stock and bond that's traded on the public market, we can easily find the value by looking at the market for that day. And so all of those values then are added together to determine the size of the estate. If the estate is less than $2 million for federal purposes, you're not going to have an estate tax that you have to pay, at least under current law. That number is going to change. It's going to go up to $3.9 million in a few years in 2009. And then in 2010, the estate tax is going to go away for 1 year. And then after 2010, unless Congress acts, it's going to go back to $1 million, which is the way it was back in 2001. So that's where we are today, though. We're at a $2 million exemption level. So unless you have an estate in excess of $2 million, you're not going to pay estate tax for federal purposes. One must caution, though, that for New York State purposes, the exemption is only $1 million. So you could easily end up paying a New York State estate tax equal to $99,500 and yet pay zero estate tax for federal purposes if you have an estate equal to exactly $2 million.
Well, listening to all that, it seems that everybody should have a will and also an analysis of their property to make sure that their property goes where they want it to go and that they won't have to pay an exorbitant amount of taxes. Why don't we talk about that next time?
Well, that sounds great.
Mark Crone will return after this commercial break. That's all the time we have for this presentation. If you have any questions you'd like answered about estate planning, you can call Mark Crone direct at 845-778-2121. Just tell the operator you listen to Up Front and Legal, and you have a question for Mark. That's 845-778-2121. And thanks for listening.